adjournment form, Lordship. I've taken consent of the other parties as well, Lordship.
At the request of the learned counsel, appearing for the appellant. List this matter again. When do you want it?
After 3 weeks, Lordship, if possible.
After 3 weeks.
Deeply obliged.
My Lord, I beg to mention item number 9. Yesterday we mentioned and it has came in item 9, we need a permission to file an additional affidavit.
The learned counsel, item number 9, give me the file.
Court number 10 to my going to he go time.
In item number 9, take down. Mr. M. Biswas, learned counsel for the petitioner, has submitted that an additional affidavit is required to be filed in the matter. Full stop. The permission is granted. List this matter again on.
Because the council has met an accident, so I'll not press for any date, my Lord. Let it be after 1 week or 2 weeks.
After a week.
And similar prayer
Along
for
with the affidavit proposed to be filed. Yes.
Similar prayer for item number 7. Here also it is against the NCB, and the NCB council has met an accident, so I'll.
The same person.
Same person.
7 and 9.
But may not be tagged together.
Huh? Why?
Because the cases are different, my Lord.
But the involvement of the person in the same kind of offences repeatedly. Okay, in item number 7 also same order.
Same order. I'm
You will file an affidavit there also.
Let the permission be there, my Lord. If required, we will file.
Yes.
For motion, item number 1.
Yes, Mr. Medhi. You are not audible. You have to switch on your mic.
May I please, Lordship? Here, my Lord, this award was passed, my Lord, on 2012 itself, my Lord. And the two award, my Lord, Annexure A and Annexure B, my Lord, this mentioned the award, my Lord. We have already made payment, my Lord. In my Lord, Annexure A, we made payment in 2013, my Lord, 31/5/2013. And Annexure B, my Lord, we made payment of award payment of 15 to 12 2012, my Lord, it is reflected we made a payment, my Lord. My Lord, the certificate, possession certificate is given of this Annexure C, page 14, my Lord, 14 and 15, my Lord. One is, my Lord, 24th January 2014, my Lord, and another is, my Lord, Annexure D, page, my Lord, this 15, my Lord, with certificate was granted on 13 March 2013, my Lord. This much is the awarded amount we already paid, my Lord. Thereafter, what happened, my Lord? The private respondent, they filed a petition under section 28A, my Lord, of the Land Acquisition Act 1894, my Lord. This is the provision, my Lord, when those who not approach the reference court, my Lord, under section 18, my Lord, then they can within a period of time they can approach this district collector, my Lord, for this enhancement of this the compensation amount or land value, my Lord. So, my Lord, accordingly, my Lord, the Annexure E, page 16, my Lord, is the district collector enhanced the land value, my Lord. My Lord, decided land value initially it was 0, my Lord. Then subsequently it was, my Lord, 25, my Lord. So, my Lord.
Just a minute. How can something be 0? Value of land can be 0 at any
point
of time?
My Lord, in Mizoram, my Lord, some these village council here, my Lord, those initially it was, my Lord, some only for they are using for crops and, my Lord, some trees, my Lord, for they use this land, my Lord. So value was 0, my Lord, it was determined, my Lord.
Okay,
so and that is one part, my Lord. That is already done, my Lord. So subsequently, it was land was this the value was, my Lord, decided 25, my Lord, by him. My Lord, at that in the order, my Lord, Annexure E, page 16, district collector, my Lord, give another, my Lord, this in his order, my Lord, this interest under section 34 and 28 of the Act, my Lord. My Lord, 34 is, my Lord. Section 34 of this Act is, I am reading section 34. Section 34 is payment for interest. I am reading, my Lord. When amount of such compensation is not paid, or deposited. When such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at the rate of 9% per annum, from the time of so taking possession until it shall have been so paid or deposited. Provided that if such compensation or any part thereof is not paid or deposited within a period of 1 month, 1 year from the date on which the possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of such period of 1 year on the amount of the compensation or part thereof which has not paid or deposited before the expiry of date. Here, my lord, we have the compensation amount, the awarded amount we paid, my lord, in the year 2013, March 2013, in Annexure A and Annexure B. It is we paid in December 2012, my lord. So the interest 34 does not arise in this case, my lord. So, but district collector, when passed the order, they in page 18, the relevant portion, page 18, the petitioner shall also be paid the interest under Section 34 of the Land Acquisition Act, be calculated separately on the total amount so assessed at 9% per annum for 1 year from the date of taking possession and 15% per annum every subsequent year beyond the expiry of 1 year up to the payment of land value, so and so and so. So and so. My lord, what happened, my lord? Under wrong advice, my lord, when the district collector assessed the interest under Section 34, my lord, the railway authority, my lord,
you were made aware of all this in the year 2022.
Yes, my lord.
You knew of this award in the year 2022.
My lord, yes, my lord. We paid that amount, my lord.
Huh?
We paid that, my lord. We paid the interest under Section 34, my lord. We already paid, my lord.
So now what do you want?
Now question is, my lord, this 34 it does not arise in the present case, my lord.
No, just
because the amount.
There was an award. You have complied with the award. You have paid the money.
Yes, my immediately,
Now
my lord.
you are trying to come back and say. Now you are trying to come back and say that I should not have paid that amount.
Now my prayer before this honorable court is that, my lord, they are again send the assessment in 2022, my lord. The Annexure H, my lord. The under Section 28, my lord. 28 of this act.
Just tell me, Mr. Medhi.
Yes, my lord.
This is payment of interest under Section 28 that you have paid in the year 2022.
No, my 34 paid, my lord. We have paid 34, my lord.
34 you have paid. When?
Yes, my lord.
When?
34 is paid, my lord. This, my lord, is
22.
it is page 22, my lord.
Okay, now you have paid the interest under 34.
34 is paid, my
now
lord.
what is your case that you should not have paid that interest under Section 34?
Yes, my as per law says, my lord.
Now tell us one thing. You paid it in 2022.
Yes, my lord.
People have spent it.
My lord, I'm not on that, my lord. I am on that, my lord. This and again they claim this same interest under Section 28. So that amount we have not paid, my lord.
So that amount was required to be paid by the order that by the request dated 13th October based on a finding of the court. Based on an award dated 26th day of August 2019. Is it?
Yes, but that is the award, my lord, the Annexure E, my lord. Annexure E.
Now from 2019, you have not paid the people.
No, my lord, no.
What is your explanation?
My lord, this is a law point, my lord. This when there's
very well. It is a law point. But have you come to this court to say that from 2019 to 2022, we did not pay because we did not want to, or we thought that the award was wrong? And then when in 2022 we got a demand, we still thought the order was wrong, the award was wrong, and now I will come back in 2025 to challenge it.
That explanation is not here. I'm Lordship me allowed to file additional affidavit in this regard.
Regarding
my lord.
what?
But
Regarding what?
But that, that part, my lord, from 2020 to
If a man,
2026, why?
if a routine petitioner comes before this court to say that, sir, I should have been paid in the year 2019, I made a demand in the year 2022, then you would say that it's a money claim, it's this and it's that, therefore, after 3 years of the cause of action arising, now nothing. Is it not?
My lord, what happened, my lord,
Why
I'm
should it be
submitting, my
different
lord.
for you?
The annexure E, my lord, this order, my lord, we have complied, my lord, all interest is given, my lord, in 2022, annexure G, my lord.
We are not on that. This order, this award may be wrong. This award may be wrong. That is for us to see when we are discussing the merit of the case, yes.
Yes, ma'am.
But when you had notice of this award and a notice for to pay the interest under section 28 in the year 13th of October 2022, based on an award passed in the year 2019, have you made any statement in this writ petition saying that this is the reason why we could not approach immediately?
No, no, my lord, that
It has
is not
taken
there.
us 7 years to find
That is
out
not
whether
there.
we should pay or not.
That is not there, man. Only thing is that we filed this petition, my lord, is under section 34 is, my lord, delayed payment, my lord. My lord, with wrong advice, we did pay the amount, my lord, my lord, all giving all interest, my lord, and under section 28 is, my lord, is all same, my lord, per 9% and 15%, same thing, my lord. So now they again, my lord, in 2022, they asked for the 28, my lord. So this orders speaks, my lord, and in the there is judgment of the apex court also, my lord. That cannot be, my lord. This interest only High Court can give, my lord, because in this case, my lord, this reference court, my lord, under section 28, my lord, says, my lord, reference court.
All said and done. Have you explained your delay in lectures in the matter?
No, my lord, it is not there. It is
not
not
even
there.
a sentence that this is why we have not been able to do it.
No, it is not there. It is not there. So, it is not there, my lord. Only if this lordship may allow to file in this explaining the delay part, my lord. Otherwise, my lord, this in the same case is pending before the principal bench, my lord, regarding, my lord, initially the amount was paid in under section 34, my lord. Subsequent again claim 28,
In that
my
case
lord.
also delay is there.
My lord, that it was there, but it was not. But the repetition was filed by railway authority, my lord. Subsequently, it was dismissed, my lord. Again, they approached the High Court, my lord, and the Honorable High Court and the Division of State did that order, my lord, regarding, my lord. So this thing is that, my lord. So if lordship is allowed or allowed to place the that
any writ appeal filed by the state has also to be accompanied by delay condonation of delay petition, is it not?
my lord, my lord,
So far delay in lectures is concerned, you may have some latitude more than what the usual petitioners
my lord,
have.
in writ appeal there is no delay, my lord.
Total non-application of anything, total non-explanation of not even a single word why it has not been paid for so long. We do not know if there is a contempt petition pending. We do not know if there is
No, this is the order of the district collector.
From
This is the order of the district collector.
From 2022, from 2019, when these people had an order in their hand, an award in their hand, we do not know what other things have in the meantime
My
gone
lord,
through.
my lord, so lordship may allow to file a additional appeal. We will clarify this,
Heard
my lord.
Mr. S.K. Medhi, learned counsel, appearing for the petitioner, full stop. The learned counsel has submitted that the present writ petition is assailing and a notice dated 13th of October 2022 issued by the district collector, Kolasik district, to the deputy CE /Bhairavi at Silchar in the Northern Frontier Railway, requesting a payment of interest for land acquisition under section 28 of the LA Act 1894. During the course of his submissions, this court has noticed that the award pursuant to which the notice dated 13th of October 2022 had been issued is of the year 2019, more precisely 26th of August 2019. Full stop. On going through the contents of the writ petition, this court could not discern any explanation for the delay of nearly 7 years from the passing of the award. Full stop. The learned counsel, appealing for the petitioner, has prayed for an accommodation to file an additional affidavit to explain to this court the absence of any willful delay or laches in preferring the present writ petition. Full stop. At the request of the learned counsel for the petitioner, list this matter again on when?
14, my lord, 14th.
14th of August.
Yes, my lord. We'll try to file,
14th
my
of
lord.
August 2026.
Earlier.
This court, at the top you read, this court has noticed that there is no reference to the course of events after the passing of the, after the request made in 2022. Full stop. That will insert some.
Earlier.
Yes.
Item number 2.
May it please your lordship, for the petitioner, I have taken steps upon respondent number 7 on 29/7/2026. However, office note dated 4/8/2026, ID card has not yet returned. Service may be awaited.
Lordship, I appear on behalf.
Just a minute, just a minute. Respondent number 7.
7.
Yes, what is it?
Your Lordship, I appear on behalf of my senior CGC, Ms. Adam Sangpui, and we have submitted Vaglanama for respondent 7 on
For
30th.
respondent number 7.
Yes, Your Lordship.
He appears.
And our affidavit had been sent to the department. However, it has not been for
The
vetting.
department.
Yes, Your Lordship, to the respondent.
Ah.
And it has not for vetting, and it has not been returned as of now.
And what about respondent other respondents? Respondent number 1, 2, who appears?
Your Lordship, I appear on behalf of respondent 1 and 7.
1 and 7.
Yes, Your Lordship.
Who appears for 2?
Your Lordship, 1, 2, 7.
1, 2, and 7.
Yes, Your Lordship.
Who appears for 3?
3 and 4 is stayed, my lord.
Huh?
I'm appearing for respondent number 5 and 6 on behalf of my senior.
No, let me find out. 1, 2, and 7 are represented. You are appearing for
5 and 6, my lord.
5 and 6. Okay. 5 and 6. Now, who appears for 3 and 4? Miss
Lordship,
Nalnun Hui.
as per last order,
Ah.
Miss Lalnun Lui
Where is
has
she?
submitted. Should be filing for Vakalandama.
Where is she? Let's call after some time. If she's not here, we'll ask the personal appearance. After some time.
Item number 3.
Lordship, this is regarding the imposition of penalty under Section 74 of GST 2017, Lordship. So,
Yes, who appears? Respondents?
Lordship, I'm appearing on behalf of my senior, the standing counsel for respondent number 2 and 3,
Who?
Mr. Johnny L. Tauchong, Lordship.
Huh?
Yes, and my lord, my senior is having personal difficulty today, so if this matter may be passed over for the day, my lord.
no, Lordship.
Huh? But then you were given the liberty to press for an interim order. What happened? You don't want to press?
I press, Lordship, as the council is absent, Lordship. So interim should be, Lordship, at least my my saving bank account which have been freezed.
It has been freezed.
Yes.
Okay.
So, Lordship, it should be released because it is sub judice. Matter is pending before the High Court.
What is their demand?
Their demand is, Lordship, that penalty should be paid 76,000.
What is your amount in the bank?
My amount in the bank,
Is it more than that?
it is not noted, Lordship.
It is not more than that.
It is.
You
So-
give some security. We can defreeze your account, but you have to give us some security.
Lordship, we are paying regularly this GST. There is no pending GST. The only thing is that we have been, assessment was made
If we
2017
allow
to 2021, Lordship.
If we allow you to operate your account, you take out all the money and then you come back and say, okay, I lose the case, but all the money is gone. What happens?
No, Lordship, we are paying regularly, Lordship. That,
Tuesday?
so-
Lordship, I appear on behalf of
Thursday,
respondent.
huh? We'll have it on Thursday.
Lordship.
And what is your name?
Dahil mga isa nga.
Counsel appears for
Respondent number 2 and 3, Lordship.
for respondent number 2 and 3 and has submitted that the leading counsel, Mr. So-and-so, is indisposed today. Full stop. Accordingly, he has paid for a short accommodation. Full stop. The learned counsel for the petitioner has submitted that there is urgency in the matter since the bank account of the petitioner has been kept under, has been freezed, and he is not being able to operate the account. Full stop. In view of the above, list this matter again on Thursday next. Thursday next would be? Huh? 13 of August 2026. Good stuff.
Obliged, Lordship.
In the event the counter affidavits are not found on record, the petitioner would be entitled to press for an interim relief.
Obliged, Lordship.
Item number 4.
May please, Lordship. In this matter also, I am appearing on behalf of my senior, Mr. Joniel Tautsong, counsel for respondent number 1 to 3. And my lord, as per his instruction, we will be submitting affidavit in opposition during the course of the day, Lordship.
Counsel for the respondent has submitted that the response to the petition shall be filed during the course of the day.
Yes, Lordship.
Good stuff. Accordingly, list this matter again on. We'll have it sometime in September,
Yes, Lordship. Yes.
3rd of September.
Yes, Lordship.
3rd of September 2026, along with the counter affidavit proposed to be filed. Full stop. Interim order
Lordship.
passed earlier to continue.
In the meantime, interim order may be continued.
You don't even listen to the order. I've already said it. Yes.
Item number 5.
My lord, this is a criminal revision petition filed by the state against the order of the learned special court NDPS dated 10/4/2024. My lord, there's a delay in filing the revision petition, 56 days delay. And I have filed my application for condonation. And today is for consideration of the delay application. Your
This is
lordship,
against what?
against an order of discharge.
The order of discharge. Yes,
Yes,
sir.
my lord.
56 days delay.
Yes, my lord.
Hmm? We'll allow the delay, we'll allow the condonation. Have the matter listed for final disposal, the revision. You are now free. You are discharged.
Yes, my lord.
No difficulty on your part.
My lord, there are some discrepancies with regard to even the summons with regard to the respondent
summons?
number 2.
Which summons?
Respondent number 2, my lord.
Respondent number 2. Who is respondent number 2?
Respondent number 2 is
Yes, she's a resident of Myanmar.
Myanmar national, my lord. And now the state has not completed their service of summons, my lord. And they claim that she is charged only under Foreigners Act, Section 14 of Foreigners Act. And legal aid counsel is appointed. Simply. without making a complete attempt for serving of summons, my lord.
My Lord, we have sent a letter to the Ministry of Home Affairs on 20th April 2026.
These people, they come here, get arrested, take a bail or take a discharge, and then they vanish. A lifetime will go searching for them. Why should the others not participate? Those persons who are traceable, why are they not participating? Why should the proceedings not go ahead with? So far they are concerned. She will look after her own welfare. What is the process of serving foreign national?
My Lord, we have sent a letter to the Ministry of Home Affairs, and we have asked for a direction on whether the Treaty on Mutual Assistance in Criminal Matters is still standing because of the current situation in Myanmar. Till date, my Lord, we have not received any reply from the ministry. That is why we have asked to proceed the matter.
And in any case, yes sir, in any case, if we condone the delay, take up the criminal revision petition, qua those respondents who are before us, we can decide whether the order was correct or not.
Yes.
And we can observe that since the respondent number 2 has not been served with a copy, she would be at liberty to assail, to enjoy the benefits till she appears and the matter is argued on her behalf. We do not know.
Okay, my lord.
What are their grounds? We do not know. What is the ground that you for this revision?
For this revision, my Lord,
Shortly, tell us.
yes, my Lord. They were discharged on the grounds that some provisions of the NDPS Act, that is Section 42 and 57 of the NDPS Act, were not followed.
Okay.
That is the only grounds, my Lord.
Heard Ms. Fumble, learned counsel, a learned APP, a learned PP, appearing for the state of Mizoram. You are appearing for respondent number?
1 and 3, my lord.
Mr. So-and-so, and the counsel appears for the respondent number 1 and 3. So-and-so appears for respondent number 2 as the legal aid counsel. Full stop. Appointed, legal aid counsel appointed by this court. Since the respondent number 2 has remained unserved,
Yes,
as she is a citizen, admitted citizen of a neighboring country. Stop. This is an application praying for condonation of delay in preferring the criminal accompanying criminal petition number 23 of 2024. The learned public prosecutor has drawn attention of this court to the contents of paragraph 2 along with its subparagraphs to submit that the delay of 56 days in filing the accompanying criminal petition was wholly attributable to official processes and the respondent authorities did not in any manner cause deliberate delay or lapses in filing the accompanying petition. The learned counsel appearing for the respondent number 1, 2 and 3 have submitted that the explanation of delay is not wholesome and deserves to be rejected. Full stop. I have gone through the contents of the grounds for condonation of delay given in the petition, and I find that there are sufficient grounds to condone the delay and take up and decide the criminal petition on merits. Full stop. Accordingly, the delay of 56 days in preferring the connected criminal petition is condoned. Full stop. List the IA accordingly disposed of.
obliged.
My lord, one more thing. Till date, I have not received the revision petition, my lord. I may be given.
My Lord, I'll serve them.
If you want the things to hurry up, you have to give it to them.
Yes.
Otherwise, they'll take this ground.
Always.
In that I accordingly disposed of, just before that you have to write registry to list the criminal petition on its turn.
Obliged, my lord.
Item number 6.
May it please your lordship.
Yes.
Here in this case, Lordship, I am seeking bail primarily on the ground that grounds of arrest were not communicated to the family members, Lordship. And they have filed their affidavit, and in their affidavit also they have admitted that it was sent, but they have not furnished any documents to show that it was served to the family members, Lordship. Paragraph 17 of their affidavit, Lordship, may I kindly see.
Paragraph 17 of their affidavit.
Yes, yes, Lordship.
Lordship, I'm appearing on behalf of the Special PP, NCB, Mr. Caesar Omsana. Since he's still hospitalized, so we have already submitted our leave note as well. It's reflected in the course list.
Relief note.
Leave note, yes, it's here.
You want to be relieved from the case?
No, leave
A
note.
leave note. I had relief note. You want to be relieved from the case? Huh?
No. So if the matter may come after 2 weeks, if possible.
What is this man name? Muhammad. Okay, Muhammad. But the CJM has made his endorsement on the screenshot.
No, they have said, Lordship, that WhatsApp status shows that it was sent through WhatsApp, and that copy was shown to the learned CGM.
It was sent to?
And this sent through WhatsApp, Lordship. The screenshot of that was shown to the learned CGM. Lordship.
You are the family is required to be given in writing.
Lordship.
Now, if in the WhatsApp they say that your husband has been arrested, that may
No,
not
they
be
have
enough.
said they have only intimated the arrest, Lordship, not grounds of
Where
arrest.
is the screenshot?
That is not there in the affidavit. But if your Lordship sees my bail application, Lordship, I have annexed the intimation of arrest, that part,
Where?
page 60. This is the intimation of arrest.
Intimation of arrest. Where is the ground of arrest?
Grounds of arrest, Lordship, it was not communicated.
Is it?
And that, yes, that 48 notice here, Lordship, will find page 61. that they said, Lordship, this was sent through post, Lordship. That receipt copy they have not furnished till today, till filing of their affidavit, Lordship. Page 61.
It was sent to?
Through post, Lordship. As per affidavit, they have said that it was sent through post. But they have not furnished any document to show that it was received by the wife of the accused, Lordship.
No, your receipt may be there or may not be there. You will give a wrong address, it will never be received. Whatever address
No,
and
Lordship,
whatever things you have
as per
given,
the-
they just need to send it to that. And there should be
No,
one
they have to-
communication to the police station. Under
Yes,
whose
police,
jurisdiction your
concerned police
residence
station will charge the
arises.
copy, Lordship.
But
Concerned police station.
today, the learned counsel for the respondent is hospitalized, under hospitalization. Should we take it up
Lordship.
today? It will be unfair.
Lordship, that
We'll fix it on Thursday next.
Lordship, if it may be...
See, a writ petition, 5 weeks, 6 weeks, no problem. This is a bail petition.
I understand, my lord. But hopefully he'll get better.
No,
that time.
what we do is this. On Thursday, we have the matter fixed. Inform your clients. Either they make an arrangement for someone to appear, and God abiding, if the learned senior counsel is well enough, he'll appear.
Your lordship.
Yes, sir. We'll put it on Thursday.
Lordship.
A submission has been made on behalf of the learned senior advocate and special PP NCB that he is not in a position to attend the proceedings today. Full stop. Accordingly, list this matter again on 13th of August 2026. Full stop. Mr. Swensul, you are Mr. A. Ahmed, huh?
Lordship.
Mr. A. Ahmed and a counsel appearing on behalf of the petitioner is present through DC. Yes, we'll have it on 13th of August.
Lordship. Obliged.
Item number 8.
Your Lordship, this application is listed for the first time. This
Sure.
application is listed for the first time, and if the notice may be issued through a registered post. It's an IA condonation.
What is the ground given?
Your Lordship, this is regarding a delay of 1,521 days in impugn heirship.
1,521 days.
Yes, Your Lordship.
But Ms. Swenson, counsel appearing for the applicant. This is a petition seeking condonation of delay of 1,521 days
Yes, Your
in
Lordship.
preparing the connected RFA. Full stop. Issue notice. Petitioner to applicant to take steps within a week. Full stop. List again on 20th of August 20th of August 2026 along with service report.
Obliged.
Passover item. Item number 2.
Yes. None appears for respondent number 2 and 3.
Lordship, the counsel for respondent number 3 and 4 is having some medical problems. She will not be attending the court today.
He heard Ms. Swenson and a counsel appearing for the petitioner. Stop. Although the office note dated 482026 reflects that the respondent number 7 that the acknowledgement due card for service of notice upon the respondent number 7 has not returned, comma, Mr. Your name?
Yun Ming Tanga.
Appears for the respondent number 7 and submits that they have filed their power. Have you filed your wakalatnama?
Yes, Your Lordship.
And they have filed their wakalatnama. Stop. The learned counsel appearing for the respondent number 1, 2 and 7
Yes, Your Lordship.
submit that they would require some more time to file the response to the contempt petition. What about you?
Lordship, I'm appearing for 5 and 6.
You don't want any time?
No, Lordship, we will not be filing any affidavit.
Why?
As per the order dated 23rd for Lordship, no obligation or duty to perform was cast upon the MADC. So unless we
Order dated 20?
23/4, that is the WPC 28, from which this contempt petition arises, Lordship.
The learned counsel appearing for the respondent number 5 and 6 submits that no duty had been cast upon the said respondents by the order dated
Lordship,
is the
page
date of the
15,
order?
annexure 1. The order is in page 15 of the petition, Lordship.
order dated
23rd
23/4/2025 passed in WPC 28 of 2025. Full stop. It has been submitted that the learned counsel appearing for the respondent number 3 and 4 is indisposed today, and the matter may be taken up on another day. Full stop. Learned counsel for the petitioner does not object to the same. List this matter again after a week, by which time the respondents would be at liberty to file their response, if any, to the contempt petition.
For hearing, item number 4.
Lords, I believe the government advocate is Ms. Vani is busy on her legs in court number 1, my lords.
Okay.
If it could be passed over.
Tuesday? We'll have it on Tuesday. You can take it.
Push him.
Huh?
Tuesday. My lords, Tuesday. Just
Tuesday? Tuesday, but we'll sit only in the second half.
My lords, we are convenient with that.
Okay. Is it okay, sir? Tuesday, second half, but let's take it on Tuesday, as the learned government advocate is stated to be engaged.
Would your lordships be, my lords, would your lordships be convenient at 12 today?
Today?
Yes. Because, my lords, all that is left is your lordships had called for the calculations to be made. Everything I heard from her, from the government advocate, that everything is ready for submission to your lordship. There is no dispute between us. Yes, between us, there's no private parties, no issue, my lords. I just have one submission. Can the government, my lords, do it posthumously? That is there.
Okay.
Or else, my lords, at Tuesday also.
No, it's okay. We'll have it. We'll try to have it today. We'll try at 12, otherwise at 2. Yes. Okay.
Item number 9.
Pleasure. No.
Yes.
Yes, Your Lordship, I'm sorry to mention that if you just give me 5 minutes so that I can collect the file. Actually, I came down from.
After that.
Item number 9.
During item 9, my lord, Miss Vani is appearing as PP as well.
Would she be prepared to, if we take up the matter today?
Yes.
Because she would take some time. She will take some time.
Yes, ma'am.
By the time, perhaps.
Yes.
Find out. Let us start. Which is ready to do it today, find out. Yes, madam.
Yes, Your Lordship, this is a POCSO matter. And this is a jail appeal under sections 376, clause 3 of IPC and read with section 6 of POCSO Act. My lord, the brief facts of the case is that on 2nd November 2018, an FIR was lodged at Dalon Police Station under the state sections by one Silal Tleipui, who is the auntie of the victim. So FIR was registered and it was duly investigated. And during investigation, the complainant and the witnesses were examined, and even the victim was also thoroughly examined, and she gave her statements also. And in her statements, she stated that her stepfather had raped her, and when she was only 11 years old. She further stated that her
I humbly submitted that I believe that the GIS and GPF cannot be recovered because
No, it cannot be.
yes, that's why. So the total will be more than 8 lakhs in the actual, because this is only the draft
No,
totaling
let us see name of the
the
official
whole
is
benefit.
so develop 6-pay calculation.
Yes. Here in 6-pay, debt gratuity, GPF, DLI, GIS, leave encashment, everything is written down here. So the total amount which come up is,
No, he expired in 22nd of July 2016.
yes,
And then, since then also they have not been paid anything.
Nothing.
nothing. So they were calculating.
Then
this
why is
17.
pension area admissible from 1918?
Yes.
And
Question remains.
and Your Lordship, another thing which I would like to submit is that if I take Your Lordship to the forwarding part, it is written that this draft cannot be exact at this moment.
I understand
because,
that.
Yes.
I understand that, but the pension area admissible from 1918 to 1726 is shown as pension area. Yes, but the man expired in 22nd of July 2016. Why take away those 2 years
Why
from his
they are
life?
doing this is, I believe that because even the pension is still hold.
Hmm?
The pension benefit is not given, even the pension is not given yet. So they were calculating the area in this one.
So area has been calculated from 1st of September. Do you see? Pension area admissible. Have you found it?
Yes. First 9.
From 19/2018. Now, if you come to the top, the man expired in 22nd of July 16. 2 years pension missing.
2016.
It is written there, date of demise at the top.
Yes, yes, yes. I don't know, Your Lordship, this one. Might be again, this is a typing mistake.
In
I don't
in
know.
any case, this is death cum retirement gratuity. The punishment did not affect his gratuity. He would be entitled to gratuity.
My lords.
It is not a dismissal of service, huh?
The rule says that gratuity is attracted for recovery. It is attracted under
Let me just clarify that point. Learned advocate is right to a certain extent. Rule 9 says either you recover part or full from pension or gratuity. Now, my lords, today is family pension, so gratuity. So I just wanted to clarify that point.
Rule 9 of
CCS pension rules, my lords.
GPF, there can be no recovery.
GPF cannot be.
DLI also, my lords.
No recovery because it is part of the GPF. It arises from the GPF. GIS is his own money. It's an insurance group insurance scheme money. He cannot take it. Leave encashment maybe.
Leave encashment and debt gratuity.
Okay, DCRJ. So leave encashment and DCRJ together would be somewhere around 13 lakhs. Now,
This in addition to, my lords, the family pension, which, my lords, your lordships knows that family pension is a different
her
definition
pension
altogether.
cannot be taken. He died in service.
Yes.
There is no pension to recover from.
So utmost respect, it cannot be, my lords, this.
So the maximum recovery you can make is of the leave encashment, which was his money,
Leave encashment and even the debt gratuity, Your Lordship.
and
we can do
death
that.
cum retirement gratuity. This.
In that regard, I have one citation, Your Lordship.
Please give.
My lords, I would not object insofar as gratuity if it can be. But my lords, what does the law say? This is our only submission. My lords, only question. My lords, Rule 9 says, Rule 9 gives a power to the president to withhold, my lords, either the pension or gratuity. Unfortunately, he has died, so pension does not arise. It's only gratuity. I am only saying today, my lords, this power was never exercised.
No.
And if it were to be, because my lords, either you recover part or full, some order has to be there.
He was serving where?
Serving, my lords, in the,
Food and civil service.
this is,
So it has to be done by the governor.
yes, it has to be.
Done by the governor. No?
Governor.
The CCS rules may be adopted,
Yes,
but it will be not ipso facto.
correct,
It
correct.
will be,
Yes,
what is it, mutatis mutandis.
yes, yes, yes.
President will be
Yes.
My lords.
substituted by governor.
No issue there, my lords. All I'm saying is even the governor, or let us take it a notch down. Let us assume it is the, my lords, the secretary or director also. Because I believe this is a group
No
C.
such order has been passed.
Nothing. And my lords, how many years have elapsed? The only question which was in my mind, my lords, I believe this should be, my lords,
What
adjudicated.
is the judgment? Huh? He's giving me a POXO judgment. He is giving me a POXO judgment.
No, actually, Your Lordship, this morning I did not file my citation. If I may be allowed to file later on.
Which is, why is this given this? P and R Sundaram?
My lords, that is
That is
that
not
is
mine.
fine. That is
What is it for?
Your lordships in R Sundaram, on that point only, my lords, in para, if your lordships comes to para 15, I'll just take your lordship there. In R Sundaram,
Kumari Madhuri Patil. That is a different case.
yes. But my lords, I just wanted to take your lordships to para 11, where my lords in R Sundaram, it refers to a judgment of state of Jharkhand versus Jitendra Kumar Srivastava. Your lordship sees that.
Jitendra Kumar Srivastav.
Yes. Page 3 of the judgment. At para 11 it starts. It refers to, my lords, state of Jharkhand.
Right to property.
Para 16 of that judgment.
So family pension is a right of the wife and the child to survive.
Yes.
It was not a right of the pension holder, the government servant. Therefore, no recovery from the wife and the child.
Here, Your Lordship, if I may read out my citation and later on I will give the copy. This is 1998 7 SCC 691, Union of India and others versus BDEF.
I think you will have to repeat the citation.
If I may read out, Your Lordship. The relevant rules in the present case is Rule 9. Learned counsel for the respondent contended before us that Rule 9 can be invoked only in the government servant as caused any pecuniary loss to the government. This contention is also unsustainable. Rule 9 as it stood at the relevant time was as follows. Right of precedence so and so, Your Lordship. And here in para 11, Rule 9 gives to the President the right of withholding or withdrawing a pension or part thereof, either permanently or for a specific period, and ordering recovery from a pension of the whole or part of any pecuniary loss caused to the government. The power can be exercised if, in any departmental or judicial proceeding, the pensioner is found guilty of grave misconduct or negligence during the period of his service. The power, therefore, can be exercised in all cases where the petitioner is found guilty of grave misconduct or negligence during the period of his service. One of the power of the President is to recover from pension.
Now show us that.
In a case where any pecuniary loss is caused. So, Your Lordship, in the present case, the negligence of the petitioner, the deceased petitioner, is proved. It's already proved, and that is admitted by himself. So the recovery can be made
Show
from
us.
the pension.
Show us that when you were taking the decision to punish him, you had forwarded the matter to the governor to say, sir, kindly recover it from his pension.
There is none, my lords, the affidavit says.
Kindly show that the day he demised or any time thereafter before today, you have written a letter to the governor saying that, sir, we need to recover. Please allow us to recover from his pension. And finally, show us that that he was getting any pension or any pension is due to him.
The documents I have to seek
See,
again,
this
Your
this
Lordship.
rule 9 has a very unique rule. A person is found to be, he is given a charge sheet. He retires in the next 5 months. Now you find him guilty.
No, Your Lordship,
The moment the
he
person
died before his pension.
uh-huh.
He died before his pension.
Take a situation where a man is given a charge sheet. He retires before the enquiry is finalized. Okay? He retires. Now, once a man retires, you cannot do anything to him.
Yes.
No recovery from anywhere because of that. What is that case? Rafiq
Yes,
Nassim.
yes,
Nothing
exactly.
from a retirement.
Yes.
Now, this rule 9 will come into play. Since it was already a continuing proceeding, and he is found guilty of causing loss to the
Yes.
state exchequer.
Yes.
Once he is found guilty, from where to recover? He does not have a salary. So the governor or the president has the power to say recovery from his pensionary dues. Yes? So that is a kind of a recovery which is related to a penalty. Now this man was penalized when he was alive.
Yes.
Order finished.
Finished. It's in finality.
No further penalty. Yes, you cannot penalize him twice. That recovery was supposed to be made from the no. He was supposed to recover from the the recovery was supposed to be made from the salary, if you understand it like that. Man is not there. Someone has to go and get the salary. The word in Rule 9 is pension. It is not family pension. The same rule contains both the terms, pension and family pension. And nowhere in the rule you will find perhaps that pension will also include family pension. Cannot be. A man, he makes some mistake somewhere. Why should the husband and why should the daughter and the son and the wife suffer? Okay.
My lords, your lordships has seen that one judgment. Authority of law, my lords. Authority is there. Nobody, my lords, denies that. Only thing is exercise.
It was never exercised.
So, my lords, there also, okay, I'm taking a step further. That is the only thing, or else your lordships has observed rightly, I would say. Gratuity should also, my lords, therefore not be recovered.
Because there is nothing in the orders to say, or nothing in the conduct of the respondents to say that the appropriate authority has decided to recover from the gratuity.
And your lordships knows reasonable period has been defined in certain judgments.
16.
And
He died in 16.
16.
10 years down the line.
As per Rule 80C, subclause 2 of the CSS pension rules, the government are authorized to make recovery of ascertainable government dues from the death gratuity payable to the family of the deceased government servant. Rule 71 further recognize adjustment of government dues gratuity. This is in the rules, CSS rule. So it is very clear that it can be the recovery can be made from the death gratuity.
Okay, now since today we have come across new arguments, new things, we will not say it is disposed of. We will allow you to file your written arguments and written arguments.
Yes.
And next Thursday we will consider it disposed of. We'll either dictate in the court or we'll. Yes, madam. Next Thursday.
Yes.
Give down in writing whatever you want to your written arguments.
Yes, I will write it down.
I'll close it on Thursday.
All right. I will write it down and
My lords, just one last statement, my lords. Today, my lords, the deceased officer, my lords, he had 2 wives. Now during the proceedings, my lords, the children of the first wife and the second wife, we've come to an agreement that, my lords, insofar as family pension, because other benefits will flow as per nomination forms. Insofar as that, my lords, we are willing to, my lords, divide amongst ourselves and on a 50-50 basis. We've made an agreement, my lords. If we can also, either if your lordships find it appropriate to file it through affidavit, we can.
No, if you bring it on record through the affidavit, we'll simply say this, that part of the order is a consent order.
Yes,
which where it will be released to one of the persons because you cannot have two pension orders.
yes.
It will be released to one, who shall thereafter within certain time period release it within the next 2-3 days to the other persons, the moment it comes into the account. So make an appropriate affidavit, will say the terms of this will, respondent number so and the petitioner have agreed that the terms of this agreement would govern this share.
Yes, yes.
Although in a writ petition we are not required to adjudicate upon the shares of the parties, but we are recording this for convenience of both parties.
I know. Extremely grateful.
You simply say, heard both the parties. Heard the learned counsel for the parties, full stop. On their prayer to be allowed to file written arguments in the matter, comma, list this matter again on Thursday. But we'll close it on that day, madam.
Yes.
Have all your judgments, all your this thing
Yes, I will submit.
on that written argument. We will not hear anymore.
Yes.
We'll simply take it on record. We'll
Yes.
close it. Thank you.
Deeply